Trey Anderson, the new assistant principal here at Hancock County Middle School. I want to welcome you back to the new school year. Today we're going to go through the Code of Acceptable Behavior and Discipline for Hancock County. You can find this document online on our district website. Once you get past the table of contents, there is a page with addresses and phone numbers for our district. Another page that has our school calendar for this school year. And on page 1, it gets into procedures followed in developing the code. A broad-based committee was developed in each school during the spring of 1985 to review existing school codes and bring them in compliance with new state regulations. Each school committee consisted of parents, students, teachers, and administrators. The high school and middle school worked independently on their codes. The 3 elementary schools met together after compiling their first drafts in order to formalize one code for all elementary schools. The central office reviewed the 3 codes and added needed information that was called for by state regulation. The final draft was given to the school board attorney for review and recommended changes, additions, and deletions. The draft was submitted to the Board of Education in the June board meeting for approval. The final approval copy was mailed to the Kentucky State Department of Education. Here are the procedures for annual discipline code preview. Each year, a county discipline committee will be formed to review the existing code. If there are no changes after review, the committee will report such to the Board of Education. If there are revisions, the codes will travel through the same steps it did in its original writing. Procedures for annual orientation to the code for students, parents, and teachers. For students, each student will receive by school administrators or teachers an orientation to the discipline code at the beginning of each school year or upon enrolling in Hancock County schools. For teachers, each school administrator will review and explain the discipline code to faculty at a faculty meeting each year before school starts. For parents, a copy of the discipline code will be available online at the beginning of each school year. Parents will then be encouraged to contact the school if there are any questions or comments. In addition, parents can request a hard copy of the code from any school or the central office. A parent and student signature sheet is included in the back of this book. Parents and students must sign the sheet and return it to schools. By signing the sheet, the parents and students will be acknowledging the fact they have read the student discipline code, they understand it, and they agree to abide by it. Assurances regarding non-discrimination, due process, and appeal procedures. The Hancock County Schools will not discriminate against any person on the basis of age, sex, marital status, race, color, national origin, religion, social economic level, handicap, intelligence, or any other reason. Evidence of such discrimination should be reported to the superintendent. Due process. Students in Hancock County Schools will be afforded due process by 1. Being notified of misconduct, how the discipline code was violated, and the charges made against them. 2. Having the right to present their cases to the charging authority. And 3, having the right to appeal any decision to the next higher authority or person until all appeal rights have been exercised. Allowances in the code for flexibility and individual review. The Hancock County Discipline Code is a set of regulations that administrators and teachers will use to govern the discipline of students. Flexibility is built into the code in dealing with student behavior by differentiating between the severity of offenses and by offering various alternative measures for dealing with misbehavior. Extenuating circumstances will be taken into account when dealing with student behavior. When and where the discipline code applies. The discipline code applies throughout the year to all students participating in educational activities, both curricular and extracurricular, anytime students are on school-provided transportation on school grounds and or under the supervision of certified personnel. So this code applies to everything you do in the school building or as part of the school outside of the school building. Personnel authorized to administer the code and the mechanisms for administering the code. The Hancock County Board of Education Discipline Code will be administered by personnel authorized by the Board of Education in accordance with board policy and Kentucky state law related to student discipline and behavior. Discipline problems, which are of a common or minor nature, are to be handled by the classroom teacher using informal in-school measures. Discipline problems, which the teacher deems to be of a serious nature, must be referred to the principal or designee. The administrator will investigate the problem and deal with it using the circumstance and the discipline code as guides for dealing with the problem. Here is the Hancock County School District discipline philosophy at the bottom of page 2. The Hancock County school system believes that an environment must be ensured in each school that is conducive to the learning process. An effective discipline code, which is characterized by uniformity, clarity, equity, and fairness, contributes to the development of this environment. The discipline code also facilitates the development of students' self-control and self-discipline. In this regard, the Student Discipline Code becomes an integral component of the educational process and a symbol of the commitment of parents, students, teachers, and administrators to the maintenance of an effective learning environment. It is for these reasons that the Hancock County School District develops and maintains a discipline code which emphasizes not only the rights of students, but also the responsibilities of students to others and to the learning process. School authorities are given a broad range of powers in ensuring that students' rights and responsibilities are harmonious with learning process. The Hancock County School District will exercise these powers with discretion and will adhere to the requirement of due process and other constitutional standards. So here on page 3, we're looking at students' rights and responsibilities. Students, as citizens of the United States, are guaranteed certain individual rights by the Constitution of the United States. In the formulation of student discipline codes, school districts shall give particular attention to the following specific rights as delineated in KRS 160.2956. Right of expression, including but not limited to appearance, assembly, association, and circulation of petitions and literature. The right to participate in decision-making procedures directly affecting students. Right to procedural due process concerning major disciplinary action as defined by the code. Right to receive academic grades based only upon academic performance. Right to freedom from abuse and threat of abuse by members of school faculties or of school facilities and administrative personnel. Right of access by a student to his or her own records and guarantee of the confidentiality of a student's academic records outside the school system, except upon written authorization of the student or his or her parents or guardians. Exceptional education students or students who have been referred for evaluation for placement and or related services have specific rights guaranteed to them by the Education for All Handicapped Children Act and the Rehabilitation Act of 1973, Section 504. All students have specific rights related to due process when they encounter a suspension or expulsion procedure. Their rights are delineated from KRS 158.150. A pupil shall not be suspended until after at least the following due process procedures have been provided. The pupil has been given an explanation of the evidence of the charge or charges against him, which constitute cause for suspension. The pupil has been given an explanation of the evidence of the charge or charges if the pupil denies them, and the pupil has been given an opportunity to present his own version of the facts relating to the charge or charges. These due process procedures shall precede any suspensions unless immediate suspension is essential to protect persons or property or to avoid disruption of the ongoing academic process. In such cases, the due process procedure outlined above shall follow suspension as soon as practicable, but no later than 3 school days after the suspension. In relation to student discipline, rights of teachers and administrators are delineated in KRS 161.190. No person shall upbraid, insult, or abuse any teacher of the public schools in the presence of the school or in the presence of a pupil of the school. Additional rights and specific circumstances are detailed in KRS 161.180, Supervision of Pupil Conduct. Students and their parents or guardians have the right to be informed of student rights and responsibilities on an annual basis. The district policy, students have the right to a system of public education that meets the needs of individual students based on reasonable guidelines, funding policy, and opportunity. A reasonable and timely notice of all rules, regulations, policies, and penalties to which they may be subject. Physical safety and protection of their personal property. Consultation with teachers, counselors, administrators, and other school personnel. Free election of their peers in student organizations in which students have the right to seek and hold office. Examination of their own personal school records by the student, their parents, guardians, or their authorized representatives. Involvement in school activities without being subject to discrimination on the basis of race, sex, or religion. Respect from other students and school personnel. Present complaints or grievances to school authorities and receive replies from school officials regarding such matters. Be members of the discipline committee. Number 2, each student has the responsibility to be accountable for his or her own conduct and for showing consideration for the rights and properties of others. Dress and groom in a manner that meets reasonable standards of health, cleanliness, and safety. Refrain from fighting, wearing of vulgar items, language, denying others the use of school facilities or buildings, using or carrying any weapon on school premises or at school activities, intentionally injuring another person or exposing others to harm, or using threats or intimidation against any other person. Refrain from gambling, extortion, theft, or any other unlawful activity. Refrain from using tobacco products or using, possessing, or transmitting an alcoholic beverage or a legal or controlled substance. Show respect for the educational process by taking advantage of every opportunity to further his or her education. Practice self-control at all times. Care for the equipment and physical facilities of the school by refraining from willful destruction and damage. Follow the rules and regulations of the Board of Education and or the school and of the school administration. Respect the reasonable exercise of authority by school administrators and teachers in maintaining discipline in the school and at the school-sponsored activities. On page 4, parent and guardian rights and responsibilities. Parents and guardians have the right to send their child to a school with an environment where learning is valued. Expect that classroom disruptions will be dealt with fairly, firmly, and quickly. Enroll students in the Kentucky County School District where they shall attend classes regularly and promptly with minimal interruptions. Expect the school to maintain high academic standards. Review the student's academic progress and other pertinent information which may be contained in the student's personal records. Address a question concerning their child to the proper authority and to receive a reply in a reasonable time period. Number 2, parents and guardians have the responsibility to instill in their children the values of an education, instill in their children a sense of responsibility, instill in their children a sense of respect. Understand that unnecessary interruptions in the school are detrimental to the educational program for all students. Be familiar with the educational program and procedures. Inform children about the disciplinary procedures of the school and emphasize the importance of following same. See that children attend school regularly and promptly. Check with the proper school officials regarding the facts of any situation that they might question. Support the efforts of the school personnel. Demonstrate respect for the teachers, administrators, school personnel at the school, and all school-related activities. See that students exhibit neatness and cleanliness in their personal attire and hygiene. Provide the school with any court orders or decrees affecting guardianship. Teacher rights and responsibilities. Teachers have the right to the support of coworkers, administrators, and parents. Work in an educational environment with a minimum of disruptions. Expect all assignments, including homework, to be completed and turned in as an assignment. Remove any student from class whose behavior significantly disrupts a positive learning environment for no more than one class period during which time the student will be in the office or other designated area. Safety from physical harm and freedom from verbal abuse may result in court action. Provide input to aid in the formulation of policies that relate to their relationships with students and school personnel. Take action necessary in emergencies to protect their own person or property or the persons or property of those in their care. Voice objections of school actions through the grievance procedure. Be informed of any legislative, judicial decisions that pertain to discipline and conduct. Teachers also have the responsibility to present subject matter and experiences to students, assess student learning, and inform students, parents, or guardians and administrators of achievement and or problems. Aid in planning a flexible curriculum which meets the needs of all students and which maintains high standards of academic achievement. Assist in the administration of such discipline as is necessary to maintain order throughout the school without discrimination on any basis. Evaluate students' assignments and return them as soon as possible. Exhibit exemplary behavior in action and speech. Exhibit neatness and cleanliness of personal dress and hygiene. Teachers should exhibit business dress as defined by the building principal. Reward exemplary behavior or work of students. Maintain an atmosphere conducive to good behavior and to exhibit an attitude of respect for students. Maintain necessary records of student progress and attendance in a timely manner and as accurately as possible. Follow and enforce rules and regulations of the Board of Education and the school administration. Care for the equipment and physical facilities of the school. Report suspected inappropriate behavior, including but not limited to child abuse, drug abuse, and emotional problems. Principals' rights and responsibilities. Principals have the right to the support of students, parents, and teachers in carrying out the educational program and policies established by the school system. Provide input for the establishment of procedures and regulations that relate to the school. Safety from physical harm and abuse. To take necessary action in emergencies to protect their own person and property or the persons and property of those in their care. Suspend any student whose conduct disrupts the educational process. Administer the school environment to provide the proper learning atmosphere. Administrators may utilize the office of the court-designated worker. Principals have the responsibility to create and foster an atmosphere of mutual respect and consideration among pupils and staff members, administer discipline fairly and equally in accordance with the conduct code, exhibit exemplary behavior in action, dress, and speech, implement and evaluate all aspects of the educational program to improve learning and comply with the policies, regulations, procedures, or laws of the district, state, and nation. Direct the school staff in developing a program which communicates this code of conduct to the school community. Support and communicate with the staff as both a group and individually. On the bottom of page 6, under the heading Grading Misconduct, no student's grades will be lowered on the basis of misconduct. Grades will be arrived at solely on the basis of scores earned by the students. Corporal punishment and physical restraint. Corporal punishment is defined as the deliberate infliction of physical pain by any means upon the whole or any part of a student's body as a penalty or punishment for student misbehavior. Effective July 1st, 1991, no person employed or engaged by any public elementary or secondary school system within this school district shall inflict or cause to be inflicted corporal punishment or bodily pain upon a pupil attending any school or institution within such educational system. Provided, however, that any such person may, within the scope of his employment, use and apply such amounts of physical restraint as may be reasonable and necessary to protect oneself, the pupil, or others from physical injury, to obtain possession of a weapon or other dangerous objects within control of the pupil, or to protect property in serious harm. All right, here's bus regulations. So for a lot of you riding the bus, here's the rules and regulations for bus rides to and from school or during extracurricular activities. Regulations. The driver is in charge of the pupils and the bus. Obey the driver promptly and respectfully. Be on time. The bus cannot wait beyond its regular schedule for those who are tardy. Wait in an orderly line off highway, street, and on school grounds. Do not run toward or across the street in front of a school bus while it is in motion. Take a seat without disturbing other passengers. Remain seated while bus is in motion. Ride only the bus assigned by the school district. Do not try to get on or off the bus or move about within the bus while it is in action. Behave on the bus as you are expected to behave in the classroom. Disobedience, vulgarity, foul language, fighting, pushing, and other offensive acts will not be tolerated. That one's pretty easy. What you do in school, same thing on the bus. Don't do it in school, don't do it on the bus. Any elementary principal has complete authority and responsibility over any high school or middle school student waiting for the bus at the elementary school. Do not engage in any activity which might damage or cause excessive wear or litter to the bus or other property. The following activities are prohibited at all times: smoking, using of tobacco products on the bus, possessing knives or sharp objects, bringing animals or specimens, throwing articles or objects, tampering with mechanical equipment, accessories, or controls of the bus, bringing food or drink onto the bus for consumption, glass containers of any kind, are all not allowed on the bus. Do not engage in any activity which might divert the driver's attention and cause an accident, such as loud talking or laughing or unnecessary confusion, unnecessary conversation with the driver, extending any part of the body out of the bus windows or doors. Report promptly to the driver any damages done to the school bus. Persons causing the damages shall be expected to defray its full cost. Always cross in front of the school bus and at a safe distance in front of the bus in order to be seen by the bus driver, a minimum of 10 to 12 feet. Do not cross the road while either loading or unloading until the bus driver motions you to cross. There will be 4 bus evacuation drills yearly. All students will be expected to participate in the drills. Any student who would have a medical reason that would prevent them from participating shall supply the school and bus driver with a written doctor's excuse prior to the bus evacuations. Part B of this is violations. Misconduct on the bus is subject to the same disciplinary measures as misconduct at school. I'll read that again so everyone hears it. Misconduct on the bus is subject to the same disciplinary measures as misconduct at school. When necessary, the principal or transportation officer may cancel riding privileges, and the student may return only when the student shows evidence that his behavior will improve. When a bus driver reports a student to the building principal for alleged misconduct on the bus, the principal must first determine the merits of the complaint. Here are some possible courses of action. reprimand the student, probation, removal of bus riding privileges for a specific number of days, form a committee of parent, principal, driver, and student to develop formal plan of action that all are in agreement with on the third removable offense. If parent does not show for meeting, or if agreement cannot be reached, the child will be sent to a hearing officer. If during the implementation of this plan the student commits another removable offense or does not abide by the agreement, the student will be referred to the hearing officer. Similar misconduct not listed here will be treated in a like manner. This is on in the middle of page 8. It shows different offenses on the bus. So abuse of other students, fighting, improper language, smoking, use of tobacco products, abuse of a driver. First offense, second offense, third and fourth, the consequences of those are all listed. And just like I said earlier, anything on the bus, anything that's prohibited or you're not supposed to do at school, same goes on for when you ride the bus. Below that, it says first and second offense can result in removal from the bus, plus whatever disciplinary school response option for that particular level of misconduct, subject to the severity of the incident. Third offense is removal from the bus and referred to the hearing officer. And after the third offense, there's also a committee that may follow page 8 under suspension and expulsion and due process. Expulsion is the most serious penalty a school can impose. Based on Kentucky State Law 158.150, a student may not be expelled from school unless provisions of Section 2 KRS 158.150 have been followed. It is therefore the policy of the Hancock County Board of Education to place a student in an isolated school setting when a student is brought before the Board of Expulsion. Conduct which proves a serious or immediate threat to safety or well-being of students or staff requires the removal of the offender from the school. When students commit serious acts of misconduct which warrant their removal from school, the district has an obligation to initiate expulsion hearings after other alternatives have been exhausted. In all instances, due process procedures must be carried out in accordance with the Kentucky law as specified in Section 2 of KRS 158.150. 158.10, suspension or expulsion of pupils. All pupils admitted to the common school shall comply with the lawful regulations for the government of the schools. A willful disobedience or defiance of the authority of the teachers or administrators, use of profanity or vulgarity, assault or battery or abuse of other students, the threat of force or violence, the use or possession of alcohol or drugs, stealing or destruction or defacing of school property or personal property of students, the carrying or use of weapons or dangerous instruments, or other incorrigible bad conduct on school property, as well as off school property at school-sponsored activities, constitutes cause for suspension or expulsion from school. B says assault or battery or abuse of school personnel, stealing or willfully or wantonly defacing, destroying, or damaging the personal property of school personnel on school property, off school property, or at school-sponsored activities constitutes cause for suspension or expulsion from school. Each local board of education shall adopt a policy requiring the expulsion from school for a period of not less than 1 year for a student who is determined by the board to have brought a weapon to school under its jurisdiction. The board shall also adopt a policy requiring disciplinary actions up to and including expulsion from school for a student who is determined by the board to have possessed prescription drugs or controlled substances for the purposes of sale or distribution at school under the board's jurisdiction, or to have physically assaulted or battered or abused educational personnel or other students at school or school functions under the board's jurisdiction. The board may modify the expulsion requirement for students on a case-by-case basis. A board that has expelled a student from the student's regular school setting shall provide or assure that the educational services are provided to the student in an appropriate alternate program or setting unless the board has made a determination on the record, supported by clear and convincing evidence, that the expelled student poses a threat to the safety of other students or school staff and cannot be placed into a state-funded agency program. Other intervention services, as indicated for each student, may be provided by the board or by agreement with the appropriate state or community agency. A state agency that provides a service shall be responsible for the cost. In determining whether a student has brought a weapon to school, a local board of education shall use the definition of unlawful possession of a weapon on school property stated in KRS 527.070. School administrators, teachers, or other school personnel may immediately remove or cause to be removed threatening or violent students from a classroom setting or from the district transportation system pending any further disciplinary action that may occur. Each Board of Education shall adopt a policy to assure the safety of the student and staff. A pupil shall not be suspended from the common schools until after at least the following due process procedures have been provided. The pupil has been given oral or written notice of the charge or charges against him which constitute cause for suspension. The pupil is given an explanation of the evidence of the charge or charges if the pupil denies them. The pupil has been given an opportunity to present his own version of the facts relating to the charges. These due process procedures shall precede any suspension from the common schools unless immediate suspension is essential to protect persons or property or to avoid disruption of the ongoing academic process. In such cases, the due process procedures outlined above shall follow the suspension as soon as practicable, but no later than 3 days after the suspension. The superintendent, principal, assistant principal, or head teacher of any school may suspend a pupil, but shall report the action in writing immediately to the superintendent and to the parent, guardian, or other person having legal custody or control of the pupil. The Board of Education of any school district may expel any student for misconduct as defined in subsection 1 of this section, but the action shall not be taken until the parent, guardian, or other person having legal custody or control of the pupil has had an opportunity to have a hearing before the board. The decision of the board shall be final. Suspension of exceptional children as defined in KRS 157.200 for more than a total of 10 days during a school year shall constitute a change of educational placement. The Admissions and Release Committee shall meet to review the placement and make a recommendation for continued placement or a change in placement and determine whether regular suspension or expulsion procedures apply. Additional evaluation shall be completed if necessary. If the Admissions and Release Committee determines that an exceptional child's behavior is related to his disability, the child shall not be suspended any further or expelled unless the current placement could result in injury to the child, other children, or the educational personnel, in which case an appropriate alternative placement shall be provided that will provide for the child's educational needs and will provide a safe learning and teaching environment for all. If the Admissions and Release Committee determines that the behavior is not related to the disability, the local educational agency may pursue its regular suspension or expulsion procedure for the child if the behavior so warrants. However, educational services shall not be terminated during a period of expulsion. A district may seek temporary injunction relief through the courts if the parent and the other members of the Admissions and Release Committee cannot agree upon a placement and the current placement will likely result in injury to the student or others. The Hancock County School District has an alternative program. In most cases, students who are guilty of expulsionary offenses in high school and middle school will be assigned to the district's alternative program. See the Hancock County High School and Hancock County Middle School handbooks for guidelines for expulsion to the alternative school. The behavior of exceptional students and students have been referred for evaluation for possible special education placement and or related services should be considered during the Admission and Release Committee meetings. Behavioral interventions, treatment, and consequences should become a part of the individual education plan for that student. Should these interventions prove unsuccessful, as evidenced by misconduct of the student, the issue should be brought to the appropriate ARC meeting to make changes in the student's program, which might result in more appropriate behaviors. In deciding Kaline v. Grubbs, June 9, 1982, the 6th Circuit Court of Appeals has outlined general standards governing the suspension and expulsion of handicapped children in Kentucky, Ohio, and Michigan. A handicapped child may be suspended temporarily without a special education change of placement procedures, not to exceed 10 cumulative days per school year. A handicapped child may be expelled as long as appropriate Admissions and Release Committee procedures are followed with a committee determination that the child's disruptive behavior was not a result of the handicapping condition. A handicapped child may not be expelled if the committee determines that the child's disruptive behavior was a result of the handicapping condition. Even if the child is expelled through the appropriate procedures, there must not be a removal of educational services. Therefore, if a handicapped child is expelled Alternative services must be provided. 504. There are certain procedures schools must follow before disciplining handicapped students under Section 504 and IDEA. The procedures which public schools are required to follow under Section 504 before disciplining handicapped students are also required under IDEA. IDEA, however, requires schools to follow additional procedural safeguards, which are not required under Section 504. As a result, the regulation which establishes the procedures to be followed under Section 504 specifically provides that compliance with the procedural safeguards of IDEA will satisfy the procedural requirements under Section 504. Under search and seizure, reasonable suspicion. No pupil's outer clothing, pockets, or his or her personal effects, handbags, backpacks, etc., shall be searched by authorized school personnel unless there are reasonable grounds to believe the search will reveal evidence that the pupil has violated or is violating either a school rule or law. Search of a pupil's person shall be conducted only with the express authority of the principal. Authorized personnel. Searches of pupil's person or his or her personal effects shall only be conducted by a certified person directly responsible for the conduct of the student or by the principal or assistant principal or the school which the student attends and in the presence of another certified person. Witness. When a pat-down search of pupil's person is conducted, the person conducting the search shall be the same sex as the pupil, and a witness of the same sex as the pupil shall be present during the search. Personal searches. No search of a pupil shall be conducted in the presence of other students. Strip searches. No strip searches of students shall be permitted. Failure to cooperate. Students who fail to cooperate with school authorities when requested to shall be subject to other disciplinary action. Regular inspection. School properties such as lockers and desks are jointly held by the school and the pupil. School authorities have the right to conduct general inspection of all school property on a regular basis. During these inspections, items which are school property, such as overdue library books, may be collected. Students should not expect privacy to items left in such locations. A single desk or locker may be searched if reasonable grounds exist to believe that evidence of a violation of the law or a school rule is contained therein. Illegal items. Illegal items, weapons, drugs, etc., or other possessions reasonably determined by proper school authorities to be a threat to the pupil's safety or other safety and security may be seized by school officials. Other disruptive items. Items which may be used to disrupt or interfere with the educational process may be temporarily removed from the pupil's possession by a staff member. Such items may be returned to the pupil by the staff member or through the principal's office. Disposition of items. All items which have been seized shall be turned over to the proper authorities or returned to the true owner. Vehicles. When reasonable suspicion exists that students' automobiles or the contents thereof pose a threat to the student health, safety, or welfare, or of the disruption to the educational process and a search is warranted, the principal or assistant principal will accompany the student to the vehicle. If the vehicle is unlocked, a search will be made. If a student refuses to open any portion of the vehicle for examination, legal authorities will be summoned and the student will lose driving privileges and appear before the board at the next school board meeting. Use of trained dogs. Subject to the following conditions, the principal may authorize the use of trained dogs to locate controlled substances on school grounds. The dogs shall be certified as never having been trained as attack dogs. The principal or principal's designee shall be present. Searches involving dogs shall be conducted only when students are in classrooms. No student shall be in the vicinity of the lockers being searched. All dogs shall be on a leash and will not be allowed to come in close proximity to any student. At the bottom of page 12, under criminal violations, students are accountable to their school in their role as students, as well as the law in their capacity as citizens. The criminal laws of the Commonwealth of Kentucky and of the federal government apply to the conduct of all persons on school property. Violations should be dealt with according to these laws and local school board policy. Due to the seriousness of level 4 offenses, the student's continued presence in school would constitute a threat to other persons and would have a negative impact on general morale of the school. Verified level 4 misconduct should result in punishment in accordance with KRS 158.150. Schools should report these offenses to the appropriate law enforcement agency and assist these agencies in investigating and prosecuting the offender. In cases of assault and or battery on a student or school employee, it is suggested that the persons press charges. The district should encourage this practice and give full support to the aggrieved individual in the legal pursuit of this matter. A student charged with level 4 misconduct should be given a full due process hearing before the board, which should take prompt and appropriate action. Since disciplinary action by a school in criminal matters does not constitute double jeopardy, the board need not await the disposition of the hearing or trial. If a student has been found guilty or has been expelled from a public or private school for an offense in violation of state law or school regulations related to weapons, alcohol, or drugs, prior to the student's admission to the school, the parent, guardian, or other persons or agency responsible for a student shall provide to the school a sworn statement indicating that the student has been expelled from school attendance at a public or private school in this state or another state for homicide, assault, or an offense in violation of state law or school regulations related to weapons, alcohol, or drugs. No records shall be transferred until proceedings have been terminated and shall reflect the charges in any final disposition of the expulsion proceedings. See Senate Bill number 112, Commonwealth of Kentucky. School officials shall cooperate with law enforcement agencies in cases involving students. As soon as possible, officials shall endeavor to notify the parents of students who are arrested. When students are arrested at school, the principal or designee shall make a written record of the identity of the officer making the arrest, the nature of the offense charged, the name of the issuing authority of any arrest warrant, and the place of custody. Crimes off school property. In the interest of the student's welfare, the following requirements shall be followed when police officers ask a question or remove a student from the school whom they suspect of committing a crime off of school property. Parents and guardians shall be notified by school officials as soon as possible. If the parents come to the school or consent to permit the officer to interview a student, a private place for the interview shall be provided. If the parent cannot come to the school and do not consent to the interview, the police should be advised to either bring a warrant, court order, or juvenile petition or arrangement to interview the student off the school grounds. Parental notifications and permission shall not be required if the student is an alleged victim of abuse by the parents. For crimes on school property, except in cases of emergencies involving threats to health and safety as determined by the superintendent, when the district calls law enforcement officials to question students concerning crimes committed on school property, the principal should make an effort to notify their parents. Any student found to have committed crimes against a school or district will not be allowed to participate or attend graduation ceremonies. This includes any misdemeanor or felony charges and also refers to students that have been accused based on probable cause that may eventually lead to charges being filed. Drug and alcohol abuse, here on the bottom of page 13. No pupil shall possess, use, be under the influence of, sell, or transfer any of the following on or about school property, at any location of a school-sponsored activity, or en route to or from school, or a school-sponsored activity. Alcoholic beverages, controlled drug substances and drug paraphernalia, substances that look like a controlled substance. In addition, students shall not possess prescription drugs for the purpose of sale or distribution. Drugs defined, controlled substances mean any substance or immediate precursor listed in Chapter 218A of Kentucky Revised Statutes, or any other substance which may be added by the Kentucky Department of Health Services under regulations pursuant to KRS 218A.020. Authorized medication. Use of a drug authorized by and administered in accordance with a prescription from a physician or dentist shall not be considered in violation of this policy. Penalty. Violation of this policy shall constitute reason for disciplinary action, including suspension or expulsion from school, and suspension or dismissal from athletic teams and or other school-sponsored activities. In addition, when they have reasonable belief that a violation has taken place, principals shall immediately report to law enforcement officials when an act has occurred on school property or at school-sponsored function that involves students' possession of a controlled substance on school property in violation of the law. Reporting. Employees of the district shall promptly make a report to the local police department, sheriff, or Kentucky State Police by telephone or otherwise if they know or have reasonable cause to believe that conduct has occurred which constitutes the use, possession, or sale of controlled substances on the school premise or within 1,000 feet of school premises, on a school bus, or at a school-sponsored or sanctioned event. Prevention program. The superintendent shall establish a comprehensive and ongoing drug-free, alcohol-free prevention program for all students, which shall include notice to students and parents of the following: the dangers of drug and alcohol abuse in the school, the district's policies and related procedures on drug-free, alcohol-free schools, the requirement of mandatory compliance with the district's established standards of conduct, including those that prohibit use of alcohol, drugs, and other controlled substances, information about available drug and alcohol programs, counseling programs, and available rehabilitation or student assistance programs, and penalties that may be imposed upon students for drug and alcohol abuse violations. At the bottom of page 14, under attendance, pupils are required to attend regularly and punctually the school in which they are enrolled. Truancy. Any pupil who has been absent from school without valid excuse for 3 days or more, or tardy without valid excuse on 3 days or more, is a truant. A pupil who has reported as truant 2 or more times is habitually truant. Absence for less than 60 minutes shall be considered tardiness. Students who are 18 or older are to be responsible to the court for their own attendance. Truants shall be reported to the principal and then to the director of pupil personnel, both of whom shall take appropriate action. Excused absences. An excused absence or tardiness is one for which work may be made up, such as death or severe illness in the pupil's immediate family, illness of the pupil, a physician's verification may be required, religious holidays and practices, an order of the court, 1 day for attendance at the Kentucky State Fair, or other valid reasons as determined by the principal or principal's designee, and lastly, military deployment. Notification. The parent or guardian shall call the school on the day of the absence and send a note stating reasons for the student's absence on the date the student returns to school. Any student that attains 15 or more excused or unexcused absences may be required to attend an attendance committee meeting to discuss a plan of action to address missed instructional days. This plan may extend beyond the current school year. The attendance committee may include the district's director of pupil personnel, school principal, teachers, school nurse, counselor, and parents or guardians. Makeup work. Makeup work shall be permitted for excused absences only. Students shall request makeup work within 2 days of their return to school. Parents should refer to student handbook for additional guidelines. Under perfect attendance, to be considered having perfect attendance, a student should be in attendance and punctual each day. To receive a perfect attendance award for the school year, a student may have one tardy and or have 1/2 cumulative excused absences or less.
Hey Lily, wake up and pay attention. Now
that Mr. Roberts has Lily awake and I've changed into my Nike shirt, let's look at the bottom of page 15 under harassment. Definition. Harassment discrimination is intimidation by threats of or actual physical violence, the creation by which whatever means of a climate of hostility or intimidation, or the use of language, conduct, or symbols in such manner as to be commonly understood to convey hatred, contempt, or prejudice, or to have the effect of insulting or stigmatizing an individual. This includes cyberbullying. Cyberbullying is when a child, preteen, or teen is tormented, threatened, harassed, humiliated, embarrassed, or otherwise targeted by another child, preteen, or teen using the internet, interactive and digital technologies, or mobile phones. Prohibition. Harassment, discrimination due to an individual's race, color, national origin, age, religion, marital status, beliefs, sex, or disability is prohibited at all times on school property and off school grounds during school-sponsored activities. This prohibition also applies to visitors to the school who may come into contact with employees and students. Acts of harassment or discrimination based on sex may be committed by persons of the same or opposite sex. District staff shall provide for a prompt and equitable resolution of complaints concerning harassment or discrimination. Felony offenses. If a felony offense is believed to have occurred on school grounds, the following will occur. School employees report to principal. Within 48 hours, principal files a written report with local Board of Education and one of 3 local law enforcement agencies: Sheriff's Office, Kentucky State Police, or County Attorney. Principal notifies parent or guardian of students. The agency receiving the principal's report will conduct an investigation. The school or board may participate in the investigation if the agency requests. Disciplinary action. Students who engage in harassment or discrimination of an employee or another student on the basis of any of the areas mentioned above shall be subject to disciplinary action, including but not limited to suspension and expulsion. Guidelines. Students who believe they have been a victim of an act of harassment or discrimination, or who have observed other students being victimized shall, as soon as reasonably practicable, inform the principal, who shall provide a form for the student to complete, and then immediately notify the superintendent and/or Title IX equity coordinator as appropriate. Employees who observe prohibited behaviors or with whom students share a complaint shall notify the principal or their immediate supervisor, who shall immediately forward the information to the superintendent. The superintendent shall provide for the following: investigation of allegations of harassment or discrimination to commence as soon as circumstances allow, but not later than 3 school days of submission of the original written complaint. A written report of all findings of the investigation shall be completed within 30 calendar days unless additional time is necessary due to the matter being investigated by a law enforcement or governmental agency. The superintendent or designee may take interim measures to protect complainants during investigation. A process to identify and implement within 3 school days of the submission of the written investigative report methods to correct and prevent reoccurrence of the harassment discrimination. If corrective action is not required, an explanation shall be included in the report. Annual dissemination of written policy to all staff and students. Age-appropriate training during the first month of school to include an explanation of prohibited behavior and the necessity for prompt reporting of alleged harassment or discrimination, and development of alternative methods of filing complaints for individuals with disabilities and others who may need accommodation. Student handbooks shall include information to assist individuals in reporting alleged harassment or discrimination. When sexual harassment is alleged, the district's Title IX coordinator, as designated in the student handbook, shall be notified. Notification of parents. Within 24 hours of receiving a serious allegation of harassment or discrimination, district personnel shall attempt to notify parents of both student victims and students who have been accused of the harassment or discrimination. Prohibited conduct. Examples of conduct and/or actions prohibited under this policy include, but are not limited to, name-calling, stories, jokes, pictures, emails, or objects that are offensive to one's gender, race, color, national origin, religion, or disability. Unwanted touching, sexual advances, requests for sexual favors, and spreading sexual rumors, being subject to unwelcome sexual remarks in the context of the classroom, impeding the progress of a student in class by questioning the student's ability to do the required classwork based on the gender, race, color, religion, national origin, or disability of the students, limiting student access to educational tools such as computers based on students' gender, race, color, religion, national origin, or disability, and teasing a student's subject choice or assignment based on the gender, race, color, religion, national origin, or disability of the student. Confidentiality. District employees involved in the investigation of complaints shall respect as much as possible the privacy of both victims and persons accused of violations. Appeal. Upon the completion of the investigation and correction of the conditions leading to the harassment or discrimination, any party may appeal in writing any part of the findings and corrective actions to the superintendent. If a supervisor is an alleged party in the harassment or discrimination complaint, procedures shall also provide for addressing the complaint to a higher level of authority. Failure by an employee, immediate supervisor, principal, and/or superintendent to report, notify, and/or initiate the investigation of alleged harassment discrimination as required by this policy to follow approved procedures or take corrective action shall be cause for disciplinary action. Retaliation prohibited. No one shall retaliate against an employee or student because she or he files a written grievance, assists, or participates in investigation, proceeding, or hearing regarding the charge of harassment or discrimination of an individual, or because he or she has opposed language or conduct that violates this policy. Upon the resolution of allegations, the superintendent shall take steps to protect employees and students against retaliation. False complaints. False or malicious complaints of harassment or discrimination may result in disciplinary action taken against the complainant. Other claims. When a complaint is received that does not appear to be covered by this policy, administrators shall review other policies that may govern the allegations, including but not limited to 09.422 and/or 09.426. Bullying/hazing. Defined. Bullying refers to any intentional or unwanted verbal, physical, or social behavior among students that involves a real or perceived power imbalance and is repeated or has the potential to be repeated, or an act by a student or groups of students directed against another student to ridicule, humiliate, or intimidate the other student while on school grounds, at a school sponsored activity, or en route to or from school or school sponsored activity, which acts are repeated against the same student over time. No one shall retaliate against a student because he or she has reported, assists, or participates in investigation of, or participates in a hearing regarding an alleged act of bullying. School administrators shall take appropriate measures to ensure that students be protected against retaliation. Students who are found to have violated this policy will be subject to the disciplinary actions as outlined in the disciplinary responses section of this handbook, page 24. If the severity of an act warrants, law enforcement will be notified and/or notification of parent/guardian as required by law. The use of lewd, profane, or vulgar language is prohibited. In addition, students shall not engage in such behaviors as hazing, bullying, menacing, taunting, intimidating, verbal or physical abuse of others, or making threats. This policy extends to any all students' language or behavior. These provisions shall not be interpreted to prohibit civil exchange of opinions or debate protected under the state and federal constitutions, where the opinion expressed does not otherwise materially or substantially disrupt the educational process or intrude upon the rights of others. Threats of violence or violent acts. Any student that makes a threat of violence, demonstrates behavior of potential violence, or acts violently towards himself or herself, another student, faculty, or staff, may be asked to complete an assessment or evaluation before they are allowed to return to school. The results of the assessment may be used when making determination for the educational placement of that student. Some assessments can be completed by the district school psychologist. If the family would like to appeal the findings of the school psychologist or use an independent evaluator, they may do so at their own expense. The assessment must be completed by a certified psychologist, advanced registered mental health practitioner, or psychiatrist. Terroristic threatening. House Bill 1, 2001 legislation amends the criminal code to enhance the penalty for making bomb threats and other threats of harm against schools, school buses, school employees, and school functions. These offenses are now felonies. Acceptable use of computers. The board supports the right of students, employees, and community members to have reasonable access to various information formats and believe it is incumbent upon users to utilize this privilege in an appropriate and responsible manner. Procedures and guidelines. The superintendent shall develop and implement appropriate procedures to provide guidance for access to electronic media. Guidelines shall address teacher supervision of computer use, ethical use of electronic media, including but not limited to the internet, email, and other district technological resources, and issues of privacy versus administrative review of electronic files and communications. In addition, guidelines shall prohibit utilization of networks for prohibited or illegal activities, the intentional spreading of embedded messages, or the use of other programs with the potential of damaging or destroying programs or data. Permission/agreement form. A written parental request shall be required prior to the student being granted independent access to electronic media involving district technological resources. The requirement permission agreement form, which shall specify acceptable uses, rules of online behavior, access privileges, and penalties for policy procedural violations, must be signed by the parent or legal guardian of minor students, those under 18 years of age, and also by the student. This document shall be kept on file as a legal binding document. In order to modify or rescind the agreement, the student's parent or guardian, or the student who is at least 18 years old, must provide the superintendent with a written request. Employee use. Employees shall use electronic mail only for purposes directly related to work-related activities. Employees shall not use a code, access a file, or retrieve any stored communication unless they have been given authorization to do so. Authorization is not required each time the electronic media is accessed in performance of one's duties. Each employee is responsible for the security of his or her own password. Community use. On recommendation of the superintendent designee, the board shall determine when and which computer equipment, software, and information access systems will be available to the community. Upon request to the principal or designee, community members may have access to the internet and other electronic information sources and programs available through the district's technology system, provided they attend any required training and abide by the rules of usage established by the superintendent. Disregard of rules. Individuals who refuse to sign required acceptable use documents or who violate district rules governing the use of district technology shall be subject to loss or restriction of the privilege of using equipment, software, information access systems, or other computing and telecommunications technologies. Responsibility for damages. Individuals shall reimburse the board for repair or replacement of district property stolen, lost, stolen, damaged, or vandalized under their care. Responding to concerns. School officials shall apply the same criteria of educational suitability used to review other educational resources when questions arise concerning access to specific databases or other electronic media. Audit of use. Users with network access shall not utilize district resources to establish electronic mail accounts through third-party providers or any other non-standard electronic mail system. The superintendent shall establish a process to determine whether the district's educational technology is being used for purposes prohibited by law or for accessing sexually explicit materials. The process may include, but not limited to, utilization of blocking/filtering software, turning off the auto-load images feature of the internet browser, using a proxy server to control accessible websites. Telecommunication devices. While on school property or while attending school-sponsored or school-related activities, whether on or off school property, students shall be permitted to possess and use personal telecommunications devices as defined by law and other related electronic devices, provided they observe the following conditions. Devices shall not be used in a manner that disrupts the educational process, including but not limited to use that poses a threat to academic integrity, such as cheating, violates confidentiality or privacy rights of another individual, is profane, indecent, or obscene, constitutes or promotes illegal activity or activity in violation of school rules, or constitutes or promotes sending, sharing, or possessing sexually explicit messages, photographs, or images using any electronic device. These restrictions shall not be interpreted to prohibit material protected under the state or federal constitutions, where such material does not otherwise materially or substantially disrupt the educational process or intrude upon the rights of others. Unless an emergency situation exists that involves imminent physical danger or a certified employee authorizes the student to do so otherwise, devices shall be turned on and operate only before and after the regular school day and during the student's lunch break. Students shall be permitted to possess and use personal telecommunications devices on school buses, provided they do not cause a distraction to the driver, and students are able to respond as needed to the driver's instructions. When students violate prohibitions of this policy, they shall be subject to disciplinary action, including losing the privilege of bringing the device onto school property and being reported to their parent or guardian. A violation also may result in a report being made to law enforcement agencies. In addition, an administrator may confiscate the device, which shall only be returned to the student's parent or guardian. Students are responsible for keeping up with devices they bring to school. The district shall not be responsible for loss, theft, or destruction of devices brought onto school property. Students shall comply with any additional rules developed by the school concerning appropriate use of telecommunication or other electronic devices. Students shall not utilize a telecommunication or similar electronic device in a manner that would violate the district's acceptable use policy or procedures or its code of acceptable behavior and discipline. The inappropriate use of camera phones that includes, but is not limited to, taking pictures of staff or students on school property or school trips is strictly prohibited. Any violation of this policy may result in forfeiture of the device until the end of the semester. Inappropriate use of a camera phone may also lead to other charges, such as sexual harassment charges, theft of proprietary information, or invasion of another's privacy. The use of telecommunication devices to engage in cyberbullying will be treated as harassment as defined in this handbook on page 17. The use of cell phones or other telecommunication devices outside of school, which can or do affect the educational environment, may result in consequences at page 21. Weapons, HB 312. Students shall not possess any weapons, firearms, knives, etc., on school property except for instructional and/or ceremonial purposes, and with the written consent of the school principal. Weapons brought onto school property for such purposes shall be rendered incapable of firing. Look-alike weapons or substances. Any toy or model weapon that looks enough like an authentic weapon to be reasonably mistaken for one will be considered a weapon. Any student who represents a look-alike weapon to a staff member or another student as a real weapon and/or who uses it to intimidate, threaten, or harass someone will be treated as if he or she used a real weapon, according to state and federal laws. Any substance that can be reasonably mistaken for a controlled substance is considered a look-alike drug. This includes non-alcoholic beer and wine. Any student who uses, distributes, or represents a look-alike drug as authentic will be treated as if it were authentic according to state and federal laws. Contagious diseases and parasites. A parent, legal guardian, or other person or agency responsible for a student shall notify the student's principal if the student has any medical condition which is defined by the Cabinet for Health Services in administrative regulation as threatening the safety of the student or others in the school. The notification shall be given as soon as the medical condition becomes known and upon each subsequent enrollment by the student in a school. The principal or designee shall notify the student's teachers in writing of the nature of the medical condition. At the top of page 22, infection control. If any student is known or suspected to have or be infected with a communicable disease or condition for which a reasonable probability for transmission exists in a school setting, the superintendent may order the student excluded from school. The time period the student is excluded from the school shall be in accordance with generally accepted medical standards, which the superintendent shall obtain from consultation with the student's physician, the local health officer, or the Kentucky Department of Public Health. Epidemics. In the event of a dangerous epidemic, as determined by the Kentucky Department for Public Health, the board may close schools. School to report. Local school authorities shall report immediately all known or suspected cases of communicable disease to the local health department. In accordance with its published guidelines, the Kentucky Department for Public Health will conduct an evaluation of the affected student's medical condition and formulate recommendations regarding school attendance. If the Kentucky Department for Public Health determines the student poses no risk, he or she will be allowed to attend school without restriction. If the student is physically unable to attend school, or if the Kentucky Department for Public Health deems the student a significant health risk to students or school personnel, the superintendent shall confer with the parents and/or the student to determine an appropriate educational environment. Medical confidentiality. Unless otherwise permitted by law, signed parental consent designating district personnel to be informed of a student's medical condition shall be on file prior to informing identified district personnel. The superintendent shall identify which employees are to have access to student medical information. This determination shall be made on a need-to-know basis. Cleanup procedures. The superintendent shall develop procedures to promote adequate and proper cleanup details and measures to aid in the prevention of infection and communicability of contagious diseases. Dress code. Ms. Sanders is going to talk about this more in her video, but here's a little bit about the dress code. The wearing of any item that materially or significantly disrupts the educational process or threatens the physical or emotional health or safety of other students or staff members is prohibited. If a school council chooses to develop a dress code, it shall be consistent with board standards set out in the district's Code of Acceptable Behavior and Discipline, which shall include but not be limited to the following. A. Students' dress and grooming shall be deemed clean. B. Students' shoes shall be worn. C. No exposed midriffs, underwear, or low-cut tops. D. No see-through garment shall be worn without proper undergarments. This includes garments with large cut armholes. E. Appropriate short skirts and dresses may be worn. Principal shall have the discretion to approve the appropriateness of these items. F. No clothing shall be worn which displays profanity, suggestive phrases, alcohol or drug advertisement, expresses violence, suggests racial bias, or is gang-related. And G. Hats and sunglasses shall not be worn inside the school building during regular school hours, except for special occasions as deemed by the principal. In the Code of Acceptable Behavior and Discipline for our district. I hope you were able to stay with me the best you could. I hope you have a great rest of your day and look forward to a good year here at the middle school.